here is the most legally precise way I can describe what just happened. The Trump administration may have found a way to defy the Supreme Court without defying the Supreme Court. The court said, refund the IEPA tariffs. CBP said, we agree in principle. Here is our multi-step process. Here is our new ACE system functionality. Here is our timeline. Everything is framed as compliance. Nothing produces immediate relief. No one is in contempt. No one is being hauled before a judge. And yet, importers who overpaid billions of dollars in tariffs the court ruled unconstitutional are still waiting. If that's not defiance, it is something arguably more dangerous, the procedural appearance of deference with the substantive effect of obstruction. That is where we are right now. And to understand how we got here, and more importantly, where this ends, you need to understand the architecture of what just happened. Because this isn't just a trade dispute. This is a constitutional stress test conducted in slow motion, and the results will tell us something fundamental about who actually controls American economic policy. Let's start with the ruling itself, because the details matter enormously here. On February 20th, 2026, the Supreme Court of the United States issued a 6-3 decision in Learning Resources Inc. v. Trump. Chief Justice Roberts wrote the majority opinion, joined by Justices Gorsuch, Barrett, Sotomayor, Kagan, and Jackson. The ruling was direct. IEPA, the International Emergency Economic Powers Act, does not authorize the president to impose tariffs. Full stop. The court's reasoning was rooted in Article 1, Section 8 of the Constitution. The power to lay and collect taxes and duties belongs to Congress. When Congress wants to delegate tariff authority to the executive, it does so clearly, with defined scope and explicit constraints. IEPA, the court held, did neither. The majority wrote, and this phrasing is worth sitting with, when Congress grants the power to impose tariffs, it does so clearly and with careful constraints. It did neither in IEPA. That is not a narrow ruling. That is not a procedural technicality. That is the court telling the executive branch that an entire category of its trade policy was built on an unconstitutional foundation. To understand the scale of what that means financially, consider the numbers. According to the Penn-Wharton budget model, IEPA tariffs generated approximately $165 billion in collections from early 2025 through the ruling date. That is not a rounding error. That is roughly half of all U.S. customs duties collected during that period. The Tax Foundation estimates that if fully refunded, those repayments would represent the largest single reversal of federal revenue collection in modern American history. So the stakes, both constitutional and fiscal, are enormous. Now, here is where the story gets complicated, and this is the part that most coverage has either missed or undersold. The Supreme Court's ruling did not order refunds. It held the tariffs unlawful and vacated the underlying authority. But on the question of what happens to the money already collected, to the $166 billion already in the Treasury, the majority said nothing. Justice Kavanaugh, in dissent, flagged this explicitly. He wrote that the refund process was likely to be a mess, as had been acknowledged during oral argument. The majority chose not to engage with that question. They left it to lower courts and administrative processes to resolve. Within 14 days, the U.S. Court of International Trade tried to fill that vacuum. On March 4th, Judge Richard Eaton issued an order directing CBP to liquidate all unliquidated entries subject to IEPA duties without applying those duties, and to reliquidate entries where liquidation was not yet final. The order was sweeping in scope. The CIT explicitly held that it was not limited to the plaintiffs in the case. Every importer whose entries were subject to IEPA tariffs is entitled to the benefit of this ruling. That is over 330,000 importers, over 53 million entries, and a refund obligation potentially exceeding $175 billion. What happened next is the part of this story that constitutional scholars will be citing for the next decade. CBP's executive director filed a declaration with the court. The declaration did not contest the ruling. It did not argue the CIT lacked jurisdiction. It said, in effect, our systems cannot execute your order as written. CBP proposed an alternative, a new set of functionalities in their automated commercial environment, or ACE, that would allow importers to file declarations, have the system validate their their data, calculate refund amounts, and then process payments in batches. The agency said this new system would be ready in mid-April, approximately 45 days from the order. On March 5th, Judge Eaton amended his original order. On March 6th, he suspended that amended order to the extent it required CBP's immediate compliance. He directed the government to file a status update by March 12th. Read that sequence carefully. A federal court issued a direct enforcement order. The executive branch filed a declaration saying it could not comply. The court then backed off the immediacy of its own order and asked for a status update. If you are a constitutional lawyer, that sequence should alarm you. Not because the court was wrong to seek clarification. Courts are entitled to understand the operational constraints of enforcement. But because the template it establishes is deeply consequential, this is a good moment to step back and frame the structural question at the center of all of this. The Supreme Court derives its authority from a single source, the expectation that its rulings will be executed. The court has no enforcement mechanism of its own. It cannot send marshals. It cannot freeze accounts. It cannot compel action through force. Its power is entirely dependent on the other branch's willingness, or the political cost of their unwillingness, to comply. Alexander Hamilton identified this vulnerability in Federalist number 78. He called the judiciary the least dangerous branch precisely because it possessed neither force nor will, but merely judgment. The system works because Congress writes laws and the executive enforces them, including judicial orders. The moment the executive branch decides, for whatever reason, that enforcement of a judicial order is operationally inconvenient, the entire architecture begins to shift. What CBP did is not as dramatic as Andrew Jackson's alleged "let him enforce it" response to a Supreme Court ruling. It is more subtle than that. CBP is not saying it won't comply. It is saying it can't comply yet. It is offering a process, it is setting a timeline, and it is betting that the operational complexity of processing 53 million entries creates enough institutional friction to delay, diffuse, and perhaps partially neutralize the impact of the ruling. Whether that bet pays off depends entirely on how aggressively the CIT presses for enforcement, how much pressure Congress applies, and whether the administration ultimately rebuilds its tariff revenue base fast enough through other authorities that the refund obligation becomes politically manageable. On that last point, the administration has already moved. Within hours of the February 20th ruling, Trump issued a proclamation under Section 122 of the Trade Act of 1974, imposing a 10% global import surcharge. That authority is constrained, capped at 15%, and limited to 150 days, but it buys time. Investigations have been launched under Section 232 and Section 301 to potentially reimpose tariffs on more legally durable grounds. The administration's posture is not retreat, it is adaptation. If you value this kind of structural analysis, tracking the institutional mechanics behind the headlines rather than just the headlines themselves, subscribing here helps this channel prioritize depth over noise. The algorithm does not naturally surface this kind of work. You do. Here is where the analysis gets uncomfortable, because it requires holding two things in your head simultaneously. On one hand, the CBP's procedural response is not inherently bad faith. The challenge of processing refunds for 330,000 importers across 53 million entries, calculating interest, handling liquidated versus unliquidated entries differently, and managing the cash flow implications for the federal government. And these are genuinely complex problems. Justice Kavanaugh's mess warning was not partisan. It was accurate. There is a legitimate administrative case for phased implementation. On the other hand, the administration's fiscal incentive to delay is enormous. Every week that refunds are not processed is a week that $166 billion remains in the Treasury rather than flowing back to importers. The government is currently running significant deficits. Section 122 tariffs cap revenue at a fraction of what IEPA generated. The longer the refund timeline stretches, the more fiscal breathing room the administration buys. The question is whether whether the courts are willing to force the pace, or whether the combination of CBP's procedural complexity argument and the sheer scale of the refund obligation creates a situation where eventual compliance becomes the operative standard rather than immediate enforcement. And here is the precedent risk that deserves to be stated plainly. If an agency can respond to a direct court enforcement order with a declaration of technical inability, and if that declaration causes the court to extend its own deadline, then the model is established. Future administrations facing adverse court orders will have a template. Commission a study of implementation complexity. File a declaration with the court. Propose a phased process with a timeline far enough in the future to blunt the immediate impact of the ruling. Then use that window to find alternative authorities, reframe the policy, or simply outlast the political moment. This is not the first time an administration has slow-walked judicial compliance, but it is arguably the most financially significant instance, and it is happening in an area, Trade and Tax Authority, where the constitutional stakes are unusually high. Let's be precise about what the next several months actually look like, because the institutional choreography here matters. CBP has indicated its refund system will be ready in mid-April. The March 12 status update will tell us whether the CIT accepts that timeline or accelerates it. If the CIT accepts mid-April, the first wave of refunds could begin to flow to importers sometime in late April or May, assuming the ACE system functions as promised, assuming the DOJ does not successfully appeal the CIT's March 4 order, and assuming the administration does not find procedural grounds to further delay final liquidation on contested entries. Each of those assumptions is fragile. The DOJ is expected to appeal the CIT's enforcement order. That appeal could result in a stay of the refund process pending resolution, potentially extending the timeline into 2027. Trump himself said publicly that the refund question would need to be litigated for the next 2 years. That is not a legal prediction. That is a policy preference expressed in legal language. Meanwhile, the Section 122 surcharge is constitutionally constrained in ways IEPA was not. It cannot exceed 15%. It expires after 150 days unless Congress acts. The administration has launched investigations that could eventually produce Section 232 or Section 301 tariffs. But those processes take months to complete and produce outcomes that are subject to their own legal challenges. The administration's tariff architecture is being rebuilt under significant time pressure, with a revenue gap that IEEPA previously filled and a refund obligation that threatens to dwarf current collections. Step back further and consider what this moment reveals about the separation of powers in the current period. The IEEPA tariffs were always legally contested. The administration knew from the beginning that the authority was aggressive and potentially vulnerable. Courts struck them down at the federal circuit level in August 2025. The administration sought and received a stay pending Supreme Court review. That stay allowed IEEPA tariff collection to continue for months after a federal appellate court had already ruled them unlawful. By the time the Supreme Court issued its final ruling in February 2026, approximately $166 billion had been collected under an authority that was already on notice of being potentially unconstitutional. The timeline matters. The administration collected revenue aggressively during the period of legal uncertainty, knowing that the refund obligation, if the court ruled against them, would be enormous and politically complex to execute. The court did rule against them, and now the refund process is, as predicted, a mess. Whether that outcome was strategic, whether the administration calculated that collecting maximum revenue during the uncertainty window was worth the downstream refund complexity, is not something we can know with certainty from public filings. But the incentive structure points in that direction. And incentive structures in institutional analysis are more reliable predictors than stated intent. So where does this end? The most likely scenario, based on the institutional dynamics, is a protracted negotiation between the courts and CBP over the pace and mechanics of refunds. A negotiation that stretches well into 2027, produces partial early payments to some importers, and remains contested on the margins for years. The administration rebuilds its tariff authority through Section 232 and Section 301 investigations, limiting future revenue exposure. Most importers eventually receive refunds, but the process is slow, administratively burdensome, and captured almost entirely by large corporations with dedicated trade counsel. Small importers, the ones the Supreme Court case was partly built around, wait longer and receive less. The alternative scenario is that the CIT refuses to accept the mid-April timeline, issues a more demanding enforcement order, and forces CBP to begin processing refunds before the new ACE system is fully operational. That path is legally available and would be constitutionally appropriate. It is less institutionally comfortable. Courts are reluctant to create administrative chaos, even when they are constitutionally empowered to do so. The scenario you will not see, the one the administration is betting against, is the court issuing a contempt finding against CBP for non-compliance. That would require a level of judicial assertiveness against the executive branch that American courts have historically been reluctant to deploy. But it is not impossible. The March 12th status update is the first real test of whether the CIT intends to be accommodating or demanding. Watch that date. What the court says on March 12th will tell you a great deal about which of these scenarios is more likely to unfold. Here is what we actually know, stated without embellishment. The Supreme Court ruled 6-3 that the IEEPA tariffs were unconstitutional. The president responded by immediately pivoting to alternative tariff authorities. The Court of International Trade issued a refund order covering every importer who paid IEEPA tariffs, over 330,000 businesses, over 53 million entries, over $166 billion. CBP filed a declaration saying it could not comply immediately and proposed a 45-day implementation timeline. The CIT backed off the immediacy of its enforcement order and requested a status update. What that sequence describes is not open defiance. It is something more precise, a sophisticated institutional negotiation in which the executive branch is using procedural complexity to slow the enforcement of a judicial ruling that carries an enormous fiscal cost. Whether that constitutes the perfect crime, compliance in form, obstruction in effect, is a judgment call that depends on how the courts respond in the weeks ahead. But here is what is not a judgment call. The constitutional architecture that makes Supreme Court rulings meaningful depends entirely on executive branch compliance. When that compliance becomes conditional, phased, subject to administrative capacity claims, and tied to timelines the executive branch controls, the architecture shifts, not catastrophically, not irreversibly, but measurably. And that shift is worth tracking with more precision than the 24-hour news cycle allows. The next date to watch is March 12th. That is when CBP files its status update with the Court of International Trade. What the court demands in response, and how specifically it holds CBP to account, will be the first real signal of whether judicial authority over this administration is a hard constraint or a soft one.